Thanks everyone for joining us today. Just our quick standard disclaimer. This information today is not legal advice. It's for educational purposes only. If you're already one of our clients and you have a question, go ahead and follow up through our portal. And if you'd like to become a client, we'll have some information at the end on making that happen. So we're going to get right into it. And what I will say, just kind of to start with, is that this is really a critical topic for employers, but it's also a topic that not every business knows about. It's kind of in the weeds. We're going to talk about a little bit in the future here as to why that is. But we want to make you aware today of this super important law that most employers are subject to, and we want to have some information for you so that if you're not currently compliant, we can help you get compliant. So with those kind of thoughts in mind, what is ERISA? Why are we talking about ERISA today? Well, it's a federal law. It was passed 50 years ago, 1974. And the purpose of the law is to set minimum standards for most voluntary pension plans and also health plans that are in the private industry, and the goal is to provide protections for individuals within those plans. It's governed by the United States Department of Labor. They kind of keep an eye on it, and within the Department of Labor, there's something called the Employee Benefit Security Administration, EBSA. They administer the ERISA rules and take care of that on behalf of the DOL. The primary responsibility of the EBSA is to ensure the integrity and compliance of the private employee benefit plan system in the US. And just kind of to give some background, before ERISA was passed, there were a lot of issues with private benefit plans in the US. If you go back to the 50s, the 60s, the 70s, back in the 20th century, there was mismanagement. There were problems with funding, vesting, reporting, disclosure about plans. A lot of workers lost their pensions as well as other benefits. So a big part of ERISA is focusing on pension plan protection for employers and employees, but really what we're going to talk about today more relate to the health and welfare plans, not the pension piece of it.
And let me just add, Michael, and is a really key piece to what we're going to talk about here. I did this same presentation Tuesday and had many questions about, there's the pension and 401k plans, and then there's the welfare benefit plans, the health, vision, dental, life insurance. We are going to talk about the welfare benefit, not the 401k and the pension plans. And this is really important to keep in mind, because you do have an investment advisor, you do have a third-party administrator, 401k matches, etc., are all done through a series of people, including your payroll department. One of the things I want you to keep in mind, I hope you take from this presentation, is, other than being confusing, the people will say, well, I have a benefit broker. I won't say the names of it, but I have one of those big benefit brokers that has their name on the building. And my insurance is through United Health. Unfortunately had a difficult and are having a difficult time, and we pray for them. But what we are going to talk about is, there is one piece that is completely dependent on you, the employer. And we'll talk about that more. We'll try to point that out. The brokers do one thing, the insurance companies do one thing, and there is something as an employer that you must do. There's actually two things that you must do. So just keep that in mind. We'll point it out when we get to those spots.
Thanks, Mark. Yeah, that's an important distinction, as he mentioned, everybody, that there's the pension piece, and then there's the health and welfare benefit piece, which is what we're going to continue talking about. And then also, as Mark said, we're going to inform you have employer obligations, and then how to get compliant if you are concerned about doing that. So what benefits on the health and welfare side are subject to ERISA? Well, you can see a whole list of them there. A lot of them are things that everyone is pretty familiar with. You know, the health, dental, or vision, health flexible spending account, an FSA if it's a standalone plan, health reimbursement account, HRA, again, if it's a separate standalone plan. There's AD&D insurance, group term life, short-term, long-term disability. These are all things that a lot of employers do provide to their employees as benefits. Again, they're welfare benefits under ERISA, and they are covered with the compliance stuff that we're talking about today. Some other things that people don't really think about maybe is covered by ERISA could be something like a severance insurance policy. People are, you know, what is that? That generally means that if a company's health insurance policy may have a provision in it that outlines a financial compensation and other obligations that an employee could receive upon termination of employment, like extending their health coverage. So that's something to be aware of. The employee wellness and assistant programs, or an EAP, those can also be covered under ERISA. People might not think of that. And then also a big area that a lot of employers see, or a lot of employers use, are voluntary benefits offered as pre-tax under a 125 plan. So that's a section 125 of the Internal Revenue Code, also known as a cafeteria plan. Generally, that's an employer-sponsored benefit that allows employees to choose from a selection of qualified benefits like health insurance premiums, and they pay with pre-tax dollars, which lowers the taxable income of an eligible employee, affecting their take-home pay in a positive way. So if you see something about a Section 125 plan, that's what it means. But overall, there are a lot of benefits, many major employment benefits that are offered by employers for employee welfare that are covered under ERISA.
I'll just add to, as Michael would say, so the Section 125 plan, the pre-tax dollars, typically brokers will call that the POP document. So if you hear POP document, those are all the same things as it relates to Section 125, and the whole idea of it is to offer a plan that provides all of these different lists of welfare benefit insurance plans at a pre-tax benefit, which is like he said, like Michael said, saves you significant amounts of dollars.
Now we talked about which benefits are subject to ERISA. So, okay, which employers are subject to ERISA? Who has to comply with this expansive and important law for employers that are providing welfare benefit plans to their employees? Well, generally it covers private sector employers. So think about corporations, so that could mean a C Corp, an S Corp, or an LLC, partnerships, sole proprietorships. You may be a sole proprietorship, but you may have employees and you offer benefits. You'd be covered by ERISA. Also nonprofits, unless they're specifically exempted as certain types of governmental entities. So that would be like a foundation, a public charity, a social welfare organization. Those may be exempted from ERISA, but many nonprofits are covered. So what this means is that basically the vast majority of private employers who offer employee welfare benefits are covered by ERISA. When I said this is a big law, it's an expansive law, that's what we're talking about. It covers really most private employers who are offering welfare benefits to employees.
And that it does include, you know, different forms of partnerships and corporations. So LLC, limited liability company, limited liability partnership, all of those things are considered private sector employers.
So now that we're talking about the law and kind of laid the foundation of what it is and who it covers, let's talk about what are some of the basic rules with ERISA that you as an employer providing employee welfare plans have to think about. So one of the things with ERISA is that there is a plan document requirement. ERISA benefits must be provided to employees through a written plan document. It can't be something that an employer just mentions verbally to an employee. You have a meeting and say, oh yeah, by the way, you guys are all getting health insurance. That's not a plan document. Importantly, with ERISA, the terms of a plan document can be combined into another document that's called a summary plan description, or SPD. That's something we're going to talk about in more detail shortly here, but that's a term to keep in mind, is the summary plan description. Really, in theory, an ERISA plan could exist without a document, but if you did that, as we had just noted, that would take your plan out of compliance with the written document requirement. So in other words, you could say you have a plan, but if it's not written down, you're not complying with ERISA. What different types of documents for a plan document? Well, it depends on what type of plan it is. For example, if you have a fully insured plan, that would be a different type of plan document than an uninsured plan. So that's just something to keep in mind as we move forward with this. Now, this is a hugely important part of ERISA compliance for an employer. What are the key ERISA reporting requirements? We're going to go through each of these because they are really something that you want to be aware of. And again, if you need to take steps to comply, you want to keep your mind in that direction with what you'd need to do. So again, if you don't follow these rules, and we'll talk about some penalties in a little bit, there are some steep penalties, so you really have to be in compliance. But let's talk about what some of these requirements are. So the plan document, or a plan document, must exist for each plan, as previously noted. All plan terms must be strictly followed by the employer. That's super important. There are fiduciary standards that must be adhered to under the ERISA law. A fidelity bond must be purchased to cover every person who handles plan funds. Basically, that's almost like an insurance policy to cover any losses if the person who's handling plan funds messes up. A summary plan description must be furnished automatically to all plan participants. Again, that's the SPD, and we'll talk more about that. And in addition, another document that has to be furnished potentially is a summary of material modification, or SMM, has to go automatically to all plan participants when a plan is amended. These are very important ERISA points that we're highlighting on this slide to keep in mind, and Mark might even have some more to say about that.
Yeah, well, again, pushing the point that I did at the beginning, these are all things that the employer is required to do. And so again, if you have a great benefit broker and you have a great insurance plan, they have certain issues that or certain documents that they have to send out. An insurance company has to send out the insurance plan, that dreaded 175 pager, and the broker generally puts together a summary of its benefits and the costs, both of which are great, but it is not the ERISA plan that you have to do. The summary plan description, Michael will talk about when those are due, but you as the employer are 100% liable for and required to provide summary plan descriptions to participants in your employee benefit plans.
And continuing with our key ERISA reporting requirements, as noted by Mark, copies of certain plan documents must be furnished to the participants and beneficiaries in some cases on written request and be made available for inspection. So that's another thing to keep in mind. A big thing that some employers miss involves IRS Form 5500. That's something that must be filed annually for each plan, for plans that have 100 or more participants. The other item to think about is the summary annual report, which summarizes the IRS Form 5500 information. That has to be furnished automatically to plan participants for any plan that files an IRS Form 5500, unless, as a side note, it's a totally unfunded welfare plan. Again,
Yeah, so,
these are,
so let me just touch on that, Michael. Well, a couple things, and I'll let you complete the 5,500 part that you were talking about. People asked on our presentation on Tuesday, do I have to send out 5,500s to all my participants? The answer is no. The 5,500 is the IRS oversees that, but the Department of Labor has built an electronic system which we use, or you could use if you wanted to. Again, the employer is required to do the 5,500 or their CPA, but there is a system that's online that allows you to do the 5,500 and file it. And, you know, again, we'll talk about when these are due. The document that you have to send out to your participants in your plan is a summary annual report. And that's a, you know, again, as it sounds, about a 2 or 3 page summary of really what had gone into the 5,500. So rather than send out, you know, some 5,500s can be hundreds of pages. The Department of Labor has said, no, we're going to let you do a summary of what goes in your 5,500. And it's really 2 things. One is to see sort of how much you're paying for all these different insurances as an employee, being able to see that, but also making sure that the 5,500 was actually filed.
yeah, these are important considerations to keep in mind. And as Mark noted, we are going to speak a little bit more about 5,500 filing in more detail in a little bit here. But this is, you know, the reporting stuff that we're covering on these last couple slides are critical for employers to be aware of. We want to talk a little bit more detail on summary plan description, SPD, as we noted earlier. So who must be provided with an SPD? As noted on the slide, there's no small plan exception. If the plan covers 1 person or 20,000, the SPD requirement is in place. It does not need to be provided to beneficiaries of the plan participants, generally speaking, but it must be furnished to COBRA qualified beneficiaries, a parent or guardian under a qualified medical child support order, that's that CSO, a spouse or dependent of deceased retiree who remains entitled to defendants has to get an SPD as well. And in addition, the SPD must be written in such a way that participants can understand it. There's a clarity of language requirement. It has to summarize the information about the particular welfare benefit plan at issue. So it has to include information on the plan administrator, who or what that is, the duties and requirements of the plan administrator. It also has to include how the plan works, who's eligible for benefits, how do you enroll, how do you file a claim, what required notices will participants receive. Those are all required elements that have to be in an SPD.
And just to, you know, hammer this point home, when Michael says no small exception, that means 1 or more. So one of the biggest mistakes we see employers making is the difference between 1 and the 100, which is the amount, the number of participants that are required to do an SPD versus a 5,500. So if you have 1 person on 1 plan, you do have to have a summary plan description or SPD for that plan. And we'll talk about if you have 100 or more in doing a 5,500.
Now, if you've picked up the information we're talking about covering SPDs in general, how do you get the SPD to the plan participants? This is also a super important area of ERISA compliance, is distribution of an SPD. So generally speaking, they should be furnished within 90 days after a participant first becomes covered. If you start a new plan, if you introduce a new benefit plan, or you're a new employer starting out providing benefits to employees, you have to do an SPD distribution within 120 days after the plan becomes subject to the ERISA rules. So after you have started it and it kicks in. Updated SPDs must be furnished to all covered participants every 5 years. or every 10 years if you have a plan that hasn't had any changes to it. How and when do you furnish an SPD? There's some different things that you have to keep in mind with furnishing or distributing SPDs to employers. One is you could physically hand a printed paper copy of the SPD to your plan participants. That is an acceptable way to distribute it. Another way would be to mail a paper copy of the SPD to your plan participants. Again, a physical paper copy through the US Postal Service. An emailed copy of an SPD can be sent to plan participants, or you can use an electronic delivery system through, say, a benefit site that's accessible to all your plan participants. And keep these overall thoughts in mind as noted on the slide here. When you're furnishing an SPD, they have to be furnished in a way that's reasonably calculated to ensure actual receipt of the material using a method likely to result in full distribution. So you want to choose one of the ways that we talked about to make sure that you're covering these requirements. You've got to be very careful in choosing and using the methods that we had just discussed when you're getting your SPD to your plan participants. And an improper distribution method, if it's not going to get to everybody, that's going to create liability for you as an employer. With those requirements in mind, you want to look at, well, how do I put an SPD together and go through the whole entire delivery process? There are some different options you can keep in mind. We're going to get into some of this that will help you with a little bit of organization and a little more convenience with some of the items we're going to talk about here. So a lot of employers have multiple plans that are covered by ERISA. If you think back to one of the earlier slides, health and welfare, dental, vision, AD&D, short-term disability, long-term disability, you've got a lot of different plans that are subject to the SPD requirement. You have to make sure, as we just discussed, as an employer, that all of your ERISA plans have an SPD, and you also have to make sure that the SPDs are delivered to the plan participants. It's a legal duty. You have to make sure that the SPDs are provided to the plan participants. And as Mark had mentioned a little bit earlier, it's a mistake if an employer thinks that this process will be covered by their broker, by their third-party benefits administrator, by the insurer themselves. They all may provide, as Mark noted, certain things to the participants, but one of the things that they are most likely not providing is an SPD. That's a requirement specifically on the employer to provide to the employees. So you can't rely on a third party to do that for you unless they're specifically engaged to do SPDs. The legal responsibility of providing an SPD falls on the employer themselves. Luckily, myHRcounsel, we have a solution that can help with your ERISA compliance stuff. We can put SPDs together for employers under some of our component services, and we can also get your SPDs put together in a more convenient place, all in one, that's known as a wrap. And also, as we kind of just pause midway through here, if you're scratching your head a little bit with some of this information, you're not alone. ERISA non-compliance is pretty common for a lot of employers. There's some various reasons for that, and overall lack of awareness, as we were just discussing. Other entities an employer may think are taking care of it for them while they're not. There can be complexity as well due to or confusion due to the complexity of the ERISA regulations. It's a huge, complex law. Also, there's been prior limited enforcement on these ERISA topics that we're talking about today. The federal government has not gone over the top in trying to bust people who are not ERISA compliant with SPDs and Form 5500s, but that doesn't mean you want to push them either. You don't want to be the employer where you're caught out of compliance and you could be subject to some pretty heavy duty penalties. So we're going to discuss some of the options of getting the SPDs to your employees. One, like we've talked, SPD, it's on its own, it covers one plan. It's a requirement for employers to have, and it's a summary of the plan information that we discussed. There's also a way, however, to provide an SPD or more than one SPD, and it's called a wraparound SPD, or as we probably would call it, an SPD wrap. Now that's a document that combines multiple employee benefit plans into a single comprehensive SPD. An SPD wrap essentially wraps around the existing plan documents and insurance policies to ensure that you're compliant with ERISA. In the SPD wrap, there's going to be necessary information all in one place, and that includes details about eligibility for participants, what benefits are, what are the claims procedures, and that's going to go across all the different plans offered by an employer. This allows for easier administration for an employer and reduces the need for multiple standalone SPDs. If you got 7 different kinds of benefit plans that are covered by ERISA, you're responsible for 7 different SPDs to employees. Instead, you could streamline that process and put them all in one SPD wrap. There's also something called a mega wraparound plan document. If you've got more than one wrap, you could wrap it with other wraps. That sounds kind of redundant, but it's a process that can potentially exist. So that is a way to get more efficient with your SPD compliance requirements and get that information out to your employees. Using an SPD wrap is really a key time and money saver for employers. It's much more organized than drafting a single SPD for every plan, like we had talked about. If you've got 7 different types of employee welfare benefits that are covered by ERISA, you're responsible for 7 SPDs, but you can streamline that process by using an SPD wrap. A wrap can also be used to supplement and include the other required ERISA documents all in one place. So it could include some terms that are subject under your insurance contracts, information on the plan administrator, could talk about designation of a fiduciary, plan years, plan numbers, plan names. All of that sponsor information can be included in the wrap, and anything that's redundant is then just listed in one single place in the wrap versus, again, as we talked about with the example of 7 different employee welfare plans, 7 different SPDs saying a lot of the same stuff. With the wrap, you're going to kind of cut that off at the knees and get it efficiently into one spot. We've mentioned the compliance requirements. Now we want to talk about some of the risks that can come into play as an employer if you do not have an SPD for each of your employee welfare benefit plans, or a wrap that covers all of the SPDs. So there might not be a fine per se if the DOL comes into your organization and is looking around and saying, oh, we don't see your SPD. Where this could come into play, though, is if the DOL is looking at something within your organization, they happen to ask about your welfare benefit plans, that can bring out a lot of these concerns that we're going to discuss here. There are more DOL investigations now regarding health plans because of the Affordable Care Act, and if an employer is not compliant in that area, that could trigger some sort of audit. So when the DOL does an audit, it will absolutely ask to see all of the plan documents of your employee welfare benefit plans, as well as an SPD for each of them. Again, having an SPD is on the employer. Not being able to provide an SPD is a very bad way to start your audit, and it could increase scrutiny from the DOL and widen what they're going to look at, how deep they're going to go with what they're looking at within your business and how you do things. So that could be wage and hour, it could be health insurance in addition to the SPD issue. What a DOL audit could uncover if you don't have an SPD is you as an employer's inability to respond to a participant request for an SPD. Under the ERISA rules, an employer must provide an SPD upon request to a participant or beneficiary. So if you don't have an SPD, your participants can legally ask you for one, and if you can't produce it, that's going to be an infraction of the law, and that's where you get into trouble if you don't have an SPD in place. without an SPD, there can also be benefit plan lawsuits. So if a participant, say, sues an employer over their, say, health insurance, and there's no SPD in place, it's going to be very hard for an employer to prove why something was done or not done according to the plan. I mean, really, it's nearly impossible for the employer to prove they didn't just make up their reasoning regarding any decision that the employee is challenging if there's no SPD on the employer side to back up the employer's position. If you as an employer have that written SPD in place, you're setting guidelines and you're going to prevent your participants from using some past practice or other outside evidence to support their claim. You know, with your SPD in place, it's going to avoid being brought into state court for, say, bad faith claims because you're not following through on your supposed promises under your benefit plans or following the ERISA rules. And there can be very, very big penalties for bad faith claims. One of the good pieces of news that we have is that it's not too late for an employer to provide an SPD if they haven't done so. Even under the ERISA rules, a late SPD is better than no SPD, so that's something to keep in mind. The real teeth in some of this, of course, are the penalties. If an employer is asked to provide an SPD, they don't have one, there are some penalties that can come into place that are significant. So one would be from the Health and Human Services, the federal agency. It's $1,406 charged to the employer for each failure to provide an SPD. So if you had multiple employees asking, that could add up. The IRS can impose a $100 fine per day per individual affected. So that's a delay penalty that could get you. And the US DOL can also impose civil or even criminal penalties if an SPD is not provided when requested to an employee. So those are things that you want to steer away from. They're avoidable, and we're going to talk about in a little bit how we can help you with some of that. But we are going to move now into the requirement for annual Form 5500 reporting, and Mark is actually going to discuss that in more detail.
Sounds good. Thanks, Michael. Let me just add one piece to this too on the SPD. You know, you probably read that and think, well, I've never been, you know, I've never had a Department of Labor audit. You know, is the government switches every 4 years. It's got, you know, every 2 years you have congressmen and women, every 6 you have Senate. So, you know, maybe it's okay. And maybe I only have 5 employees. So how hard, you know, how bad can it be? The one area that we actually see the biggest risk is if you have not, if you do not, again, why Michael says, get an SPD out even if it's late. But if an employee, let's say, has a heart attack and has all sorts of medical expenses, and they don't know or didn't know that they didn't have insurance or that the company didn't have insurance, one of the things that plaintiff attorneys do is they have they'll have a paragraph, it'll be standard paragraph that will say there was no summary plan description, meaning the employees did not know that they didn't have insurance. Otherwise, the employee would have never gone and spent $875,000 on, you know, a new heart and everything else. I have actually been in federal court, in state court on many of these issues. And one of the standard, probably the first paragraph is they didn't have a summary plan description, which means they didn't describe to their employees what sort of insurance or any insurance they have. And the courts almost all the time go against the employer on that because, again, sitting through this painful ERISA presentation, you should know if you come out of this that if you have one employee on a welfare benefit plan, on a health, a life, or whatever, have a summary plan description. Just get it done. And there's, you know, again, there's ways to do it. info@myHRcounsel.com, and we're taking care of it for a couple $100. Not a big deal. So let's talk about the 5,500s, because the IRS doesn't want to be, left out of this. It's so brutally difficult to track the ERISA and what does ERISA mean, and wait a second, my broker does this, wait a second, my insurance company clearly they must do that. Again, no, you as the employer are responsible for it, but you're also responsible for a 5,500. And I'm just going to hit a couple of the high points, just to keep it in mind. And luckily, you still have several months until a 5,500 is due if you have a calendar year plan. There's significant penalties for not doing a 5,500. You can see on this PowerPoint. There's $2,600 of penalties for each day that a 5,500 is missing. And you'd say, well, that the IRS probably can't come up with that. Though they will. They'll send out a letter, and then you'll get into a negotiation with them to come back to some reasonable amount that you can afford to pay. But bottom line is, the 5,500 is a required document, and it's required for companies that have 100 or more participants on day one of the start of your plan year. And so if you think about that, you could have 101 employees on January 1. Your 5,500 is going to be due at the end of the next year. End of the year, it's done. It's required 7 months after the end of the year. So you have 12 months and 7 months to get the 5,500 due. If you started off with, again, a life insurance policy or a health policy that has 101 participants. If during the year you have to let 20 people go and you end up the year with 80 participants, you still have to do a 5,500. It is not during the year, it is not at the end of the year, it is on the first day of the plan year. So when you think about open enrollment and the different things that you do, keep that, that invoice to see how many participants you have in these different welfare benefit plans, because you may have a 5,500 due for several plans that have 101. A lot of times group life has, you give to everyone, and it has more than 100 participants, and you will have a 5,500 that is going to be due. There is, I don't know if this is great news or good news, but there is a little bit of light at the end of the tunnel on some issues. Most of our clients, during the Trump administration, they put different rules in place such that a lot of the federal rules and the federal obligations didn't have to get filed. And so many people have gone years, if not since the start of their plan years, doing a 5,500. And they ask us, what is a 5,500? Does that have something to do with summary plan description? But isn't that just if you have more than 100, or is it one? Or if you have 100 participants at the beginning of a plan year, you will have a 5,500. The good news is, if you see this 2,670 fine, if you would, from the IRS, and there's different fines for daily not having a 5,500 done, not doing it in the right way, putting it on a piece of paper and writing it in versus the Department of Labor's online system. One of the things that the IRS has done, along with the Department of Labor, is to have a sort of get caught up, or what they call the delinquent filing volunteer compliance program. So if you had gone 3 years, if you had gone 5 years without a 5,500, and you think about hundreds of dollars, if not thousands of dollars for 5,500s that are missing, we've done a little chart that have shown it's, over about 5 years, you're getting close to $600,000-700,000 in IRS fines if you didn't, if you haven't done your 5500s. The Department of Labor, however, and the IRS together does have a delinquent filing voluntarily compliant program, and what that does, it allows you to basically, file a 5500, say myHRcounsel, and send in a different system that the Department of Labor has. Again, something we would help you with, but it maxes out the excuse me, the penalties at $2,000 a year per 5500. And so, rather than $750,000 in fines, if you have, let's say, 15500 that you had to file for a group term life insurance policy, and you missed a year, if you file under the delinquent filer program, your maximum penalty is going to be $2,000 versus several hundred thousand. If you have never filed a 5500 for that group life and life policy, and let's say it's been 10 years, imagine if that was, $100 a day, you would be at millions of dollars of penalties. The IRS and the Department of Labor has a maximum for your plan of $4,000 total dollars. So really a critical piece. Again, it's one of these things where nothing has happened yet to me. Summary plan description, no one has looked for that. 5500, I haven't been busted for it. No one has come to me. Still take care of these different things, because again, for a couple of $1,000, and then again, staying in compliance after that, what we're seeing now is, again, whether it's the 5500 or the summary plan description, yes, the Department of Labor could sue you over that, and they could come in and take a look. Yes, the IRS could send you a notice that we don't see any 5500s. But even worse than that is if something happens to one of your employees and insurance doesn't cover their hundreds of thousands of dollars of medical insurance, and you don't have a summary plan description and you don't have a 5500, those are going to be put into the lawsuit, and it's going to add hundreds of thousands of dollars to the lawsuit that employee has. One of the reasons they do that is not only does it go to the plaintiff attorney, but it gets shared with the employee, and it's against the insurance policy, it's against the employer, and a lot of plaintiff attorneys, which are not Michael and I, like to have all the possible dollar amounts so that if a judge says, well, we're not going to fine them for not having a summary plan description, but we are going to fine them a couple $100,000, or we're going to make them pay for the insurance because they didn't let the employees know that they didn't have health insurance, and there was no summary plan description, and there's no public. The 5500 is public information, so if you wanted to go on and see if your company has a 5500, and again, it has to be 100 employees or more, but if you wanted to say, oh, there's 500 employees, they should have a 5500, you can go on, again, as it's public information, to see if you have a 5500 that is compliant and that has gone through the Department of Labor's IRS system. Again, as it's an obligation to have that 5500 with 100 participants every single year. There's just no way around it. And again, if you have delinquent 5-10 years, make sure that you get a hold of us as soon as you can, and let's fix the thing with the maximum penalties and not have that penalty continue to grow.
So to sum up, we do want to talk about how we can help you with your ERISA compliance questions. Ask us. We have component services that are specifically set up to address ERISA compliance from providing an SPD to the Form 5500 filing, as Mark was just discussing, that's something that we do, and we have benefits available. We have different services, myERISA Wrap, ERISA Complete with 5500. We have a standalone 5500 service. That's something that we can assist you with. Another thing that we can do with those component services is evaluate your risks. We can take a look at what you are, or I should say where you are with your compliance process under those services if you have them with us, and help you decide on some next steps. And then we can actually provide the wrap document to you. We can take care of getting a 5500 done for you under our targeted component services that do cover ERISA matters for you.
And I would add, you know, maybe one of the things to take away from this presentation is get a hold of your broker and find out, do you have these things taken care of? They shouldn't have them taken care of because it is you as the employer that's obligated to do that. The broker should have brought that up to say to you that this is an obligation you as the employer must do. The other thing is, and for those of you that know us, those of you that are clients, you know, our big thing is we are legal information. This is a law firm, and so when we do wraps and documents and that, we do not have disclaimers that says this is just a template. You should really check this with your ERISA attorney. We are ERISA attorneys, and there are several companies out there that have a template that you know, can be, they make it look like it is an SPD or a wrap document. You can't really fake the 5500. But there are brokers that, because of the very low price, that will give you either include or give you an email to go to these non-legal solutions. And if that's what you have, you know, again, I won't name the companies there. I don't think that's fair, but I'm happy to share that with you if you want to get a hold of us. But just make sure this is a really big deal. I know this is, if you know, you do need to do some reading in the Department of Labor's monthly summaries and that to find out these, you know, again, these penalties and how these things are coming through. We're trying to give you the summary of that. But don't use fake legal solutions either. It really doesn't do you any good. We have tried to, and I think we've even beat our prices being lower than these non-legal solutions. So again, we're not in it to you know, slap you with thousands of dollars of legal fees. We have built a system that allows for very convenient use and work with you, with our attorneys, to be able to get the summary plan description. And remember, it only takes one employee or the 5500. And again, it's 100 employees at the first day of the plan year. And getting those things done on an annual basis with our fees is much, much lower than the penalties and even the delinquent filing fines that they come back with. Again, we've been able to do this for a long enough time. I think I've done it for 33 years, and so we do have component services that make this very simple for you to not only get caught back up in compliance services, but stay there.
And actually, everybody,
Michael?
Yeah, we want to just, on the last slide, we just want to say a couple things. First, thank you for tuning in, listening today. And secondly, our slogan, remember, compliance is not optional, meaning you as an employer need to be in compliance with all the rules we discussed today. So get a hold of us if you have questions so that we can help you out.
Very good. And I'll just say ditto and thank you. And remember, you as the employer are obligated for summary plan descriptions. The giving information to your employees in normal language that they should be able to understand that has to go out in 90 days. And, again, we're coming up to the end of December. So, you're coming up on 90 days or so. Right now we're, 105 days until that document, is due to your participants. And it takes a little bit of time to make sure that you have the addresses, and you make sure that you can't send out these documents just to their personal emails, maybe one that you had 20 years ago. You need to do a little bit of work to make sure that these documents do in fact get to your employees, so that they don't come back again and say, what do you mean I got this bill for $100,000 for a knee surgery? I thought we had health insurance. And that's where you're really going to get yourself into trouble. So again, we're here to help you. And if this was helpful or just colossally confusing, we'll continue to do this, because again, we have summary plan descriptions due in 90 to 100 days, and then we'll have 5500s that will be due 7 more months into 2025 for 2024. So we'll talk more about 5500s in several months as things get closer, but we hope that you learn some things from this, and if not, at least learn that you can always reach out to us.